Your
How
Honor.
how many motions do you have?
The plaintiff has two substantive motions. Would you like a brief factual background before I get to the motions?
I've read the file, so I think we're good on that.
Perfect, Your Honor. And our first motion is to admit Exhibit 15. Exhibit 15 is an internal memorandum written by the defendant's executive vice president. Now, this memo discusses some key aspects of the defendant's window design, including their size, durability, and safety. The parties have already stipulated that Exhibit 15 is authentic, and we offer it into evidence now.
Response?
Yes, Your Honor, this was actually going to be one of my motions to exclude. We want to exclude this.
Good. We'll cover them both at the same time then.
Yes, Your Honor, we will. We move to exclude this document under 401 relevance or 403 substantially more prejudicial than probative. Would you like me to share my screen with the document so that we can look at it?
No, I've seen the document. These are the text messages. Is that right?
No, Your Honor.
I'm sorry. This is the draft of the email. Yeah, I've seen that. Okay.
Yes, Your Honor.
And so what is your reason for excluding it?
Yes, Your Honor. Like you mentioned, it is a draft document. We've actually already agreed to pre-admit Exhibit 16. That's the final version. We don't have anyone from AeroCoach here today, including Marcos Rosales, who wrote this memorandum, to tell us about why these red lines were added, why the company was having this internal discussion. But the fact of the matter is that Exhibit 16 shows what AeroCoach ultimately adopted as their views on these safety measures, including glazing on windows. It would substantially mislead or confuse the issues for the jury to show them this draft document when we have the final version that shows AeroCoach's views. As such, we move to exclude this document under 401 or 403.
All right, Mr.
May I
Matz?
respond, Your Honor?
Yes.
Yes, this document is relevant because it has statements by the defendant's executive vice president about key aspects of their windows. Now, in Exhibit 15, the defendant's executive vice president says that unglazed windows, the type of windows the defendant uses, are admittedly dangerous. Now, an employee of the manufacturer of a product saying that product is dangerous is absolutely probative. It makes it more likely that that product is in fact dangerous. So it's relevant under Rule 401. As to Rule 403, opposing counsel has said that, well, this was a draft and we have the final statement of AeroCoach in Exhibit 16, but we're not offering this as a statement of the company. We're offering it as a statement of the company's employee, their executive vice president. And again, for the reasons I just said, those statements are probative and there's no substantial risk of prejudice or misleading the jury. There's no risk that the jury will be misled as to who made these statements because the memorandum says who it's from, the executive vice president of the defendant, and the defense counsel has already stipulated.
All right, thank you. Ms. Kunkel, your reputation has preceded you. I think that you will do an admirable job on cross-examination when this exhibit comes up. I'm going to allow it.
Yes, Your Honor.
The plaintiff has one further motion, Your Honor, and that's to exclude any argument that the driver of the bus was negligent under Rules 401 and 403. Now, in this jurisdiction, for the defense to argue that a third party's negligence relieves them of some liability, they would have had to have designated that third party as a responsible third party prior to today's trial. Defense counsel did this for Gary Winters, the driver of the SUV, but not for the bus driver. Thus, any argument that the bus driver was negligent is irrelevant under Rule 401 and substantially more likely to confuse the issues for the jury than it is probative and inadmissible under Rule 401.
Let me ask you a question. Have you spoken to the opposing counsel? Do you know if she is going to make that argument?
Yes, Your Honor, we did meet and confer with the opposing counsel and told them that we'd be bringing this motion, but they said that they weren't willing to stipulate to it and they would like to handle it with Your Honor.
All right. Ms. Manzano, are you responding to this one?
Your Honor, she's actually going to handle our mid-trial motion and our end-of-trial motion. I'm handling this one for now.
All right.
So, Your Honor, first of all, counsel's already opened the door to this evidence. As they told you, we actually pre-admitted Exhibit 8. That's the NTSB report. And it mentions that the driver of the bus was distracted while he was operating that motor vehicle. So the jury's going to see this evidence either way. Furthermore, Your Honor, this is relevant for two reasons. First, it goes to show the fact that causation cannot be proven by the plaintiff. If some other factor out of Aero Coach's control is what caused Courtney White's injuries, such as the driver being distracted, then they cannot meet their burden that the design of the bus caused her injuries. So it rebuts that. And then the last point here, Your Honor, we're going to show that Courtney White was in the bus. She saw this bus driver taking his eyes off the road, and yet she still chose to stay out of her seat, to not buckle her seatbelt. This goes to the reasonableness of her actions. As such, this driver distraction evidence, the fact that he was making eye contact with another passenger, it is admissible.
Brief response, Your Honor?
So, not yet. The jury charge, are you going to ask that the charge be amended to add the driver of the bus as a responsible third party to have his negligence compared or not?
No, Your Honor, amendments to the jury charge are not permitted in this jurisdiction. The way that the jury would evaluate this actually is in that very first jury question when they're asked about causation. That's where this evaluation would come in on that verdict form.
So you're going to argue that, but you're not going to ask for, but there's not going to be any instruction to the jury or question to the jury about it, other than the causation.
Correct, Your Honor.
All right. Response?
Yes, Your Honor. That first jury question actually says that our burden today is to prove that the defendant's design defect was a cause of Miss White's injuries, not that it was the only cause. So evidence that the bus driver may also have been a cause of her injuries doesn't actually relieve the defendant of any liability. So that evidence is still argument that the bus driver was negligent and inadmissible under rules 401 and 403.
I'm going to overrule the objection. I will allow the testimony. Okay. Defense, you had two motions also, or one?
Yes, Your Honor. Exhibit 15 was taken care of. And then our other motion we discussed with opposing counsel prior to trial, that was to exclude exhibits 18 through 22. So that wraps everything up for us. We're ready for trial.
All right. Both sides ready to proceed?
The plaintiff's ready to proceed. If I may have one moment to adjust my webcam, Your Honor.
All right. I'm glad you're not asking me to do that. Okay. So we are ready for the opening, and that's going to be from Miss Diamond, Gold Diamond, excuse me.
Yes, Your Honor, just one moment.
Are you ready? Now you're ready.
Yes, Your Honor, thank you. May I proceed?
Yes. Can you hear me?
I can hear you, Your Honor.
Yes, you may proceed.
Thank you very much, Your Honor. Too big, too weak, too cheap. It's the 4th of July here in Lone Star. Every storefront has a flag in its window. Every backyard smells like barbecue. And everywhere you go, you can hear the pop, pop, pop fireworks in the distance. Courtney White and her friends are excited. They're standing in a parking lot decked out in red, white, and blue, waiting for the bus that's going to take them to a concert. Oh, look at that bus, she says to her friends. It has the biggest windows. We'll have the best view. What she doesn't know is that there's a problem with those big windows. What she doesn't know is that in an accident, the glass in those windows is unusually prone to shattering. And what she doesn't know is that in an hour, in less than 1 hour, shards of broken glass from those windows will be slicing at her legs, her arms, her face. Ms. White, would you please turn on your video? Members of the jury, this is Courtney White. She grew up here in Armadillo, graduated from Armadillo High School and then the community college down the street. Today, she's going to tell you all about that bus ride, about how an SUV crashed into the bus, about how the windows exploded, about how she was showered with broken glass. Thank you, Ms. White. Members of the jury, it was the defendant, Aero Coach Bus Corporation, that designed those windows. The evidence will show the defendant chose windows so large they were likely to shatter in a crash. The evidence will show the defendant chose a grade of glass so fragile those windows were likely to shatter in a crash. And the evidence will show that a safer alternative material was available to the defendant for just a few dollars more. That's why Ms. White is suing the defendant for her injuries. Because their windows were too big, too weak, too cheap. Now, as the plaintiff, we have the burden of proof. And we have to prove that the defendant's defective windows were a cause of Ms. White's injuries. And we're going to meet that burden by proving 3 facts. A bus needs to be designed to keep people safe in an accident. The defendant's bus was not. And it was that defective design that caused Ms. White's injuries. Let's take these one at a time. Fact number 1, a bus needs to be designed to keep people safe in a crash. Now today, you're going to hear that this accident happened because another driver crashed into the bus. And you're going to hear that when the accident happened, Ms. White, she wasn't wearing her seatbelt. But the evidence will show that a bus needs to be designed with this exact scenario in mind. You will hear expert testimony that a safe bus is designed with the expectation that accidents will happen, and designed with the expectation that when those accidents happen, most people won't be wearing a seatbelt. And that's why you'll hear that a safe bus company, they do what they can to design their windows so that they're less likely to shatter, so that people don't get ejected, so they aren't showered with broken glass. Second fact we're going to prove, the defendant's bus didn't do that. Lynn Murray will take the stand. Mr. Murray is a mechanical engineer. Mr. Murray is the only person you're going to hear from today who has ever designed a bus. Mr. Murray is going to testify the defendant's windows were too big, too weak, too cheap. Mr. Murray will explain that large windows are more likely to shatter in a crash, and that the defendant has the largest windows in the industry. Mr. Murray will tell you that if a bus company wants to make their windows stronger, more resistant to shattering, they can laminate them, coat them with chemicals, or use a process called advanced glazing. The evidence will show the defendant did none of these things. But not because it was impossible. Because today you will hear evidence that for less than $100, less than $100, the defendant could have replaced every single window on their bus with safer glass. In fact, today you will see an internal memorandum written by the executive vice president of the defendant corporation where they say our glass tends to break into shards. In the defendant's own words, our glass is admittedly dangerous. Fact number 3. It was the defendant's defective windows that caused Ms. White's injuries. Today, Ms. White's going to take the stand. She's going to tell you what happened when the SUV made contact with that bus. She'll explain the defendant's windows, they didn't crack. They didn't pop out. They shattered. She'll tell you about glass flying through the cabin. She'll tell you how she was showered with shards of glass, how those shards shredded her skin. And members of the jury, we acknowledge AeroCoach didn't cause this accident. AeroCoach couldn't have prevented this accident. But the evidence will show the defendant should have protected its passengers in this accident. That's why at the end of this trial, we'll ask you to find the defendant liable for Ms. White's injuries. Because their windows were too big, too weak, too cheap. Thank you.
All right, Ms. Manzano, are you prepared to proceed?
Yes, Your Honor. May I proceed?
You may.
Out of control. When an SUV driven by Gary Winters crashed through a highway median and slammed into a bus. When the plaintiff was not in her seat on the bus. All of this was out of AeroCoach's control. 5 years before this accident in 2014, AeroCoach designed and manufactured a bus. To do that, they listened to regulations on how to make that bus safe and compliant. But beyond the moment that bus was rolled off the manufacturing line, AeroCoach had no control. They wouldn't be driving the bus. They wouldn't be controlling what passengers do on the bus. They certainly have no way to affect how other drivers on the road behave around that bus. All of these factors were beyond AeroCoach's control. Fast forward 5 years, where those factors created a perfect storm for this accident. You'll hear about the people who were in control of what happened on July 4th, 2019. Gary Winters and Courtney White. That afternoon, an AeroCoach bus was driving down I-20 when it started pouring rain. Just after that sudden rain, the bus came to the top of an overpass and a line of stopped cars came into view directly ahead. There was some backup on the highway and the bus driver almost couldn't brake on time. He swerved the bus into the left lane, barely avoiding an accident until from the other side of traffic, Gary Winters in his SUV tore through the median and crashed into that AeroCoach bus. The plaintiff will describe this accident in explicit detail because she had a perfect view of all of it. Because she was standing up on that moving bus, watching it all happen. When the bus tops that overpass, the plaintiff was standing. When she saw the line of cars ahead of her, the plaintiff was standing. When the bus jerked into the left lane, barely missing an accident, the plaintiff was standing. When she saw Gary Winters in his SUV barreling towards her, the plaintiff was still standing. He observed all of this and never chose to sit down. Lone Star DPS officer Taylor Jokel is here today. Officer Jokel investigated this accident, and based on his investigation, he'll confirm that Courtney White's description is right. In reality, the plaintiff was a great eyewitness because she was standing with a clear view of everything that happened. Now, today the plaintiff has a burden to show you not just that she was injured in this accident. Her burden is to show you that her injuries were because of a design defect in that Aerocoach bus. The plaintiff has to show you by a preponderance of the evidence, by the heavier weight of the evidence, that if it wasn't for a design defect back in 2014, when that bus was made, Courtney White wouldn't have been injured in this accident 5 years later. The plaintiff also has to show you that back in 2014, there was an alternative design that was safer and economically feasible or affordable for Aerocoach to use. They will not be able to meet this burden. Today, we will introduce you to an expert mechanical engineer. His name is Dr. Andy Zielinski. Dr. Zielinski will tell you point blank that there is no federal regulation, no Lone Star regulation that Aerocoach violated when it designed that bus in 2014. Plaintiff brought a mechanical engineer to court today too, named Lynn Murray. Mr. Murray will agree with Dr. Zielinski on that point and will have to admit the following as well: that the seatbelts on that Aerocoach bus fully complied with every regulation, that the windows on this bus fully complied with every regulation, and that the roof on this bus did not crush on impact, complying with the regulation. Lynn Murray will tell you that he doesn't like the windows because they were large and unglazed, but he can't tell you with certainty that glazed windows would have prevented the plaintiff's injuries. Mr. Murray cannot and will not tell you that the bus was defective in its design. At the end of the day, Dr. Zielinski will tell you this bus was not unreasonably dangerous. If that's the case, why are we here? We're here because of the person who did have control on July 4th, 2019, Gary Winters. You've heard that name a few times already. Gary Winters is not in court today because unfortunately he did die in this accident. Mr. Winters was the driver of the SUV, the person who plowed through a median on an 80-mile-per-hour highway and slammed into this bus. The court put Gary Winters on the verdict form today as what's called a responsible third party. Our job is to prove to you that Gary Winters caused this accident that caused the plaintiff's injuries. And you'll hear he was the cause when Courtney White takes the stand. You'll hear he was the cause again when Officer Jokel takes the stand. Now, we've also asserted what's called an affirmative defense, which means it's also our job to show you that the plaintiff's injuries were caused, at least in part, by her own actions, her own choice to stand on that bus and put herself in a very vulnerable position. Aerocoach is not responsible for a passenger like the plaintiff who chose to stand on a moving bus on the highway. Aerocoach is not responsible for a driver like Gary Winters. Throughout this trial, when you think about Aerocoach, you have to think about the year 2014, the last time that Aerocoach had control. Think about what Aerocoach was required by law to do and listen to what they did. But when you're thinking about the plaintiff and Gary Winters, think about July 4th, 2019, the day of this accident, and look at how and why this happened. When you're thinking about Courtney White, you have to go inside the bus. You have to be right there with Courtney when she chooses not to sit down again and again and again while she watches Gary Winters lose control. After this trial, you'll understand that Aerocoach did not cause this accident, did not prevent this accident, and had nothing to do with the plaintiff's injuries. You'll understand that this accident was out of Aerocoach's control. When you do, we'll ask that you find Aero Coach did not have a design defect and that Gary Winters and Courtney White are liable. Thank you.
All right. Plaintiffs, can you call your first witness?
Yes, Your Honor, the plaintiff calls Courtney White. May I proceed?
You may proceed.
Good afternoon.
Hello.
Could you please introduce yourself to the jury?
Sure. My name is Courtney White.
Where do you live, Ms. White?
I live here in Lone Star.
What do you do for a living?
Well, I used to be a lipstick model.
Why did you bring this lawsuit?
Because about 2 years ago, I was in a terrible, terrible bus accident and I got hurt.
Where were you headed on that bus?
I was headed towards a concert in Red Rock, Lone Star.
What day was the crash?
It was July 4th, 2019.
Can you summarize your injuries?
Yes, ma'am. I was cut on my legs, on my shoulders, and obviously on my face.
Ms. White, who manufactured that bus?
Aero Coach.
Let's talk about the defendant's bus. Are you familiar with photographs of the bus?
Yes, ma'am. I remember what the bus looks like.
All right. I'm going to show you a photograph of what's been marked Exhibit 1. It's already in evidence. Just going to give my co-counsel a moment to catch up. Ms. White, does Exhibit 1 accurately depict how the outside of the defendant's bus looked before the crash?
Yes, ma'am. That's what it looked like.
Then I want to focus on the size of the windows. Before you got on the defendant's bus, did you see any other tour buses around?
I did. I did see multiple buses. It was like a big thing with multiple kind of buses going.
How did the size of the windows on the defendant's bus compare to those other windows on the other buses?
These windows were the biggest of all the buses that were there.
And when you say the windows on the defendant's bus were bigger than all the others, which windows specifically are you referring to?
The ones on the sides,
Now I want to take a look inside.
really all of them, honestly.
Oh, my apologies. Go ahead and finish your answer.
I was just going to say, I think really it was all the windows. I don't. All the windows.
Yes, Ms. White, thank you very much. I want to move on now to talk about the inside of the bus. Now, Exhibit 10 is already in evidence. Does it accurately depict the inside of the defendant's bus?
Yes, ma'am.
So how close do the defendant's windows get to the ceiling?
They're pretty much to the top of the ceiling.
About how low to the floor do the defendant's windows go?
About waist height.
Would you say they're about even with the bottom of the seats?
Yes, ma'am. Like kind of where your bottom is when you're sitting in a chair, right next to your waist there.
Now, Ms. White, I want to address something the defense talked about in their opening statement. At the time of this crash, were you wearing a seatbelt?
No, ma'am.
Why not?
I mean, I was on a bus. I didn't see anyone else wearing seatbelts. I wasn't wearing one.
At the time of this accident, were you sitting or standing?
I believe I was standing.
Why?
I was just stretching my legs.
Now I have a few questions about the crash itself. Where did the accident take place?
On the road, right after we went over an overpass.
And what happened?
It just suddenly started raining, and then the bus suddenly stopped, and then we ended up rolling over because we got hit by this vehicle, and then just glass shattered and it was flying everywhere.
Ms. White, when the bus rolled over, where did you land?
I landed on the left side of the bus, I think, in a pile of glass.
During this crash, did you suffer any head injuries?
No, ma'am.
Any broken bones?
No.
Did you suffer injuries, any other injuries, cuts from broken glass?
No other injuries. No, just these real bad cuts.
So then let's talk about that glass. Ms. White, does Exhibit 2 accurately depict what the defendant's bus looked like after the crash?
Yes.
Then I want to zoom in on those windows then. When the bus was hit by the car, what happened to the windows on the defendant's bus?
They all just shattered.
Did those windows shatter before or after the bus hit the pavement?
No, immediately on impact, the windows shattered and there was glass flying everywhere.
How many windows on the left side of the bus shattered?
It was all of them.
And when all of the left side windows shattered, where did the glass go?
I mean, it just flew around. It was all over the place, all over me.
How much glass did you see flying through the bus?
It seemed like a lot.
How did you get cut?
Like I said, the glass was flying through the air and it slashed me up.
Thank you, Ms. White. We pass the witness.
May I proceed with cross-exam, Your Honor?
Yes, you may.
Ms. White, you boarded this Aero Coach bus on the afternoon of July 4th, correct?
Yes, ma'am.
When you got on the bus, you noticed that the bus had seatbelts.
Yes, ma'am.
So you asked the driver if passengers were required to wear those seatbelts.
I did.
He told you that Aero Coach put those seatbelts there for a reason, right?
I think so.
When you got to your seat, you never actually did buckle your seatbelt, did you?
No, no one did.
Now, ma'am, it's fair to say that your knees were almost touching the back of the seat in front of you, isn't it?
That's right.
Your knees weren't actually touching the seat back, were they?
No, I don't think so.
And at some point, you got uncomfortable because of that, so you stood up to stretch your legs. Is that right?
Yes, we'd been on the bus for about 40 minutes. That was pretty uncomfortable.
After this accident, using your words, you really wished you hadn't been standing up on that bus.
Yeah, hindsight's 2020.
Using your words, you wish you had been sitting down.
I think it might have helped. I don't know.
You believe it might have helped because you think if you were sitting down, you wouldn't have been thrown around that bus.
I'm sure.
And ma'am, at some points you even turned around and you stood backwards on that bus.
I think so.
You remember that while you were standing backwards, you noticed another passenger on the bus looking at the driver.
Oh yes, Miss Phillips.
Now, ma'am, throughout the ride, you also noticed that the driver was making eye contact with Miss Phillips as well, right?
That's right.
You noticed more than once that his eyes were off the road and looking at this other passenger, didn't you?
I did see that, yes.
Ma'am, when you saw that, you didn't think to sit down at that point?
No, I didn't expect the wreck to happen.
Now, ma'am, at some point, you must have turned around and faced forward again because you noticed when the bus came to the top of an overpass, didn't you?
That's right.
When the bus tops that overpass, you were standing out of your seat.
I think so, yes.
And it was raining right around this point, right?
Right.
And as it rained, you were standing.
Right.
You didn't think to sit down during the rain.
No, I didn't think there was a rule that said when it's raining, you have to be sitting on your bottom in the bus.
And ma'am, when you saw stopped cars ahead of your bus, you were still standing, right?
That's right. It was a split second and then the crash happened.
And ma'am, before the crash happened, it was longer than a split second because you felt the driver swerve to the left, didn't you?
I did feel that, yes.
And when you felt that, you were still standing.
Correct.
And then you saw an SUV plowing across the median, right?
That's right.
Now, sitting in court today, you know that it was Gary Winters driving that SUV, don't you?
I've heard his name before. Yes, I believe he's deceased now.
Yes, ma'am. And when you saw Gary Winters in that SUV coming towards the bus, you were still standing.
Yes.
Ms. White, when Mr. Winters hit the bus, you were not thrown into the seat ahead of you, were you?
No, we weren't hit from behind. We were on the side. So the bus started to roll. So I was not thrown forward. No, ma'am.
When Mr. Winters hit the bus, you were thrown from your standing position into a pile of broken glass. Is that right?
Yes.
Thank you, ma'am. I have no further questions.
Redirect.
Yes, Your Honor. Ms. White, defense counsel just asked you a lot of questions about when you were standing and whether you were wearing a seatbelt. So I want to ask, which parts of your body would that seatbelt have covered?
So the seatbelt covered just my waist. It would have covered like where my hip bones are when you're sitting down.
Which parts of your body were showered with broken glass?
It was my legs, my shoulders, and my face.
Thank you for your testimony, Ms. White. We have nothing further.
All right. Will the plaintiffs call their next witness?
Yes,
Your Honor,
Your
may Ms. White be excused?
She may.
Plaintiff calls Lynn Murray. May I proceed?
You may.
Good afternoon, Mr. Murray.
Good afternoon.
Could you please introduce yourself to the jury?
Yes, my name's Lynn Murray.
What do you do for a living?
I'm an engineer by trade.
What kind of engineer are you?
Mechanical engineer. I focus on designing vehicles, buses at the moment.
Did you evaluate the design of the AeroCoach View bus?
I did.
Specifically, did you evaluate whether the windows on that bus were properly designed to keep passengers safe in a crash?
I did. The windows were my focus.
Before we get to your conclusions, I want to give the jury a sense of your credentials. What degrees do you hold?
Yes, I hold a bachelor's and a master's degree in mechanical engineering.
What experience do you have with vehicle design?
Yeah, so after I graduated, I went to work at Volvo Trucks, and I designed trucks there for 10 years. And then after that, I went to work for a school bus company and designed school buses for another 10 years. And then I currently started a consulting firm on engineering issues as well.
Are you familiar with the industry standards for bus safety?
I am.
Are you familiar with the federal laws regulating bus safety?
I am.
I want to talk about your conclusions in this case and how you came to them. What evidence did you rely on in evaluating the defendant's bus design?
So first and foremost, I looked at the bus. I looked at the windows of the bus. I looked at the post-crash. I looked at the injuries of the plaintiff, the cuts. The fact that they were cuts made me focus on the shards of glass. I read internal memos by the defendant where they make certain admissions and acknowledgments. I read depositions, look at federal regulations, accident reports, stuff like that.
What methods did you use to analyze that evidence?
Yeah, it really goes back to my degrees. You look at it from a mechanical engineering perspective. I look at it from my knowledge of designing trucks, and I looked at it from my knowledge about windows and the difference in non-glazed windows and glazed windows, and used my background to evaluate them.
Are those methods reliable?
They are.
Did you apply them reliably to the evidence in this case?
I did.
Were you able to form your conclusions to a reasonable degree of scientific certainty?
I was.
Mr. Murray, were the defendant's windows properly designed to keep passengers safe in a crash?
Unfortunately, they were not.
Your Honor, I'm sorry to interrupt. If I remember pretrial correctly, you just said that we should formally tender our experts before we get into opinions. We just ask that counsel do that before we move into these opinions.
Well, I have a slightly different recollection. I don't remember that whether you raised that issue of tendering experts or not. I don't recall that you did. If I would ask this, if my view is he doesn't have to tender an expert. If you have objected or you do have an objection to the expert as to his qualifications, and you want to take him on voir dire to show that he is not, use your time to show he's not an expert, we can go that way, but I'm not going to require him to tender it.
No, Your Honor, my apologies. I think that I was mixing up a trial that I've been working on for another case. My apologies.
No worries.
So, Mr. Murray, were the defendant's windows properly designed to keep passengers safe in a crash?
Unfortunately, they were not.
Was there a safer alternative design for those windows?
There was.
And if the defendant had used that safer alternative design, would Ms. White have been injured?
She would not have.
I want to break down what you just said, starting with your conclusion that the defendant's windows were not properly designed to keep passengers safe in a crash. Now, we're displaying Exhibit 1 here. It's already in evidence. Why do windows matter when a bus is in a crash?
It's really common sense. I mean, it's glass windows around a tour bus. When you're in a crash, windows can break. And when windows break, they can shatter like they did in this case. And as you can imagine, shattered glass going through a bus full of 30 plus passengers can be very, very dangerous. And as we see from Miss White, it was dangerous in this case.
What factors make a bus window more likely to shatter?
And so it's twofold, and these issues go hand in hand, and it dovetails with my opinions, but it's the size of the windows. As you can imagine, if we're talking about a very small window, well, that very small window shattering may not be as dangerous because there's not as much glass. So it's the size of the windows. And Aerobus itself acknowledges these were the biggest windows in the industry, and that's consistent with what I've seen from buses. These windows were huge. And the second is, you would think if a company is going to design a bus with the biggest windows in the industry, they would take a very, in my opinion, cheap way to ensure that these huge windows don't shatter, and that's called glazing. And so those go. If you're going to have huge windows, you got to glaze them, and Aerobus chose not to.
Well, I want to break down what you just said to talk about each of those factors. So let's start by talking about the size of the defendant's windows. And I know you already said this, but I just want to make sure we're clear on it for the jury. Why did you conclude that the size of the defendant's windows made them defective?
Two. So they're the biggest in the industry. And with windows that size, not having them glazed, they go together. The bigger windows, bigger shards of glass. Bigger shards of glass, more cuts, more windows, more people that can be cut. And so the size of the windows made it more likely that these windows would shatter, and that the shattered glass would be bigger and more capable of cutting passengers.
Mr. Murray, we've got Exhibit 16 up here on the screen now. It's already in evidence. What is Exhibit 16?
This is a memo from the defendant, specifically the VP, Marcos Rosales, excuse me.
And in this memo, what does the defendant say about the size of their windows?
So this is consistent with what I was talking about. They themselves say it's the largest windows in the industry.
I want to turn to that second factor you were talking about, glazing. Now, were the defendant's windows strong enough to keep passengers safe in a collision?
The opposite. They were too weak to keep passengers safe, and that's from the glazing and the size.
So you've said that they were too weak because of the glazing. What is glazing?
So I guess the simplest way to explain it is people have seen car windows, the front windows. When something hits it, they shatter or they break, but they don't shatter forward. They kind of break it and something keeps it there. Similar to bus, when you glaze a bus window, the window may break, but it doesn't shatter and shoot glass everywhere. Glazing takes two pieces. There's different processes, but the most common takes two pieces of glass with a laminated piece in the middle, and it prevents this shattering. And that's what we're referring to as glazing. There's chemical ways of doing it. There's lamination and chemical, but that's what we're talking about. We're talking about glazing.
In your electronic notebook, do you see Exhibit 25?
I do. Can you give me a page number on the PDF, please?
Yes, I absolutely can. So we're going to be looking at the second page of Exhibit 25, and that's going to be on page 136 of your PDF.
Okay.
Now, the photo on that second page, what is that photo of?
Well, this is what I'm talking about. This is of glazed glass.
Your Honor, plaintiff offers that photo into evidence as Exhibit 25A.
Any objection?
No, Your Honor.
It's admitted.
So, Mr. Murray, we're looking at Exhibit 25A on the screen now. You said this was a picture of glazed glass. Is the glazed glass in this picture shattered?
It's broke, but as I mentioned, the glazing keeps it from shattering, from cutting passengers.
Does that distinction between breaking and shattering matter for passenger safety?
In this case, it means everything.
And why is that?
Because if a window, a glazed window breaks but doesn't shatter, Miss White wouldn't have been cut.
How many of the defendant's windows were laminated?
0.
How many of the defendant's windows were treated with those protective chemicals?
0.
How many of the defendant's windows used any glazing at all?
0.
Mr. Murray, were you here during the defense's opening statement?
I was.
Did you hear when they said that what happened in this accident was out of the defendant's control?
I did hear them say that.
Mr. Murray, what company had control over what windows went in this bus?
Aerobus, the defendant.
Mr. Murray, in your electronic notebook, do you see Exhibit 15?
I do. Give me a second and I'll get there. Okay.
Is Exhibit 15 an internal version of that memo we were looking at in Exhibit 16?
It is.
We've got Exhibit 15 up here on the screen now. Now, what does the defendant say about the safety of unglazed glass?
He says that the unglazed glass is admittedly dangerous.
What does the defendant say about the tendency of unglazed glass?
It tends to break in shards, which is consistent with my testimony.
I want to turn to your second conclusion, that there was a safer alternative design. Now, when the defendant designed the bus that Miss White was riding on, was glazed glass available?
Certainly. Many companies use glazed glass.
How much would it have cost to build a bus with glazed glass instead of unglazed?
Objection.
80s.
Lack of foundation. May I be heard outside the presence of the jury?
You can.
Your Honor, we've heard no foundation that this witness ran any sort of calculations, ran the numbers to determine how much it would cost Aero Coach to glaze those windows. And as such, this opinion lacks foundation.
Response?
Yes, Your Honor. The witness has already testified that he has experience with designing buses and experience with the industry standards for buses. He's familiar with how they're built and how much those things.
Well, just a minute. I understand that he testified to that, but I haven't heard him testify that he had any experience with the cost of doing any of these things, including the cost of glazing the windows.
Mr. Honor, well, we believe that that is part of his foundation of his experience designing buses. Obviously, designing these things involves how much they're going to cost. You don't design things in a vacuum. So he does have that experience. If Your Honor would like, I can lay further foundation on that.
I think that would be necessary.
So, Mr. Murray, as part of your work for this case, did you review research done by the National Highway Transportation and Safety Administration?
I did.
Did that research include information on how much it would cost to build a bus with glazed glass instead of unglazed?
It did.
So, Mr. Murray, how much would it have cost to build a bus with glazed glass instead of unglazed?
$87.
Is that $87 for one window or for all of them?
All of them.
Let's turn to your last conclusion, that if the defendant had just used that glazed glass, Miss White wouldn't have been injured. Now, Mr. Murray, are you familiar with any crashes similar to this one where the bus had glazed windows?
I am.
How is the crash that you're referring to similar to the one in this case?
It's very similar. A bus was struck. A bus rolled over on its side. The only significant difference between the two is going to be the glazing versus the unglazing. Both hit the ground. One bursted, shattered everywhere. That was the bus in this case. The prior crash with glazed windows, it broke like the picture you saw earlier, but it didn't shatter.
So just to break down what you just said, when that bus with glazed windows rolled over, how many of the windows shattered?
Shattered, 0.
When that bus with glazed windows rolled over, how many passengers were cut with shattered glass?
None.
Thank you, Mr. Murray. Pass the witness.
Counsel, Ms. Kunkel,
Yes, Your Honor. May I proceed with cross-examination?
you can.
Thank you. Mr. Murray, you talked a moment ago about a memorandum from within Aero Coach. Do you remember that?
I do.
You know that it was written by an employee of Aero Coach, don't you?
That's right. I think it identifies the executive vice president, Marcos Rosales.
Right. And you know that there were some redlined words on that document, weren't there?
That's correct.
You actually talked about some of those redlined words a moment ago.
I did.
And you know those words did not end up in the final version of that memorandum, did they?
Yeah. The Aero Coach chose to keep those opinions internal and not external.
Well, sir, you never spoke to Marcos Rosales, who wrote that memo, did you?
Experts typically don't get to speak to the defendant's employees.
Mr. Murray, I'm not asking what's typical. I'm asking if you spoke to Mr. Rosales, and you didn't, did you?
I did not.
So you did not ask him why he wrote those words, did you?
I did not.
You did not ask him how he came to those opinions, did you?
That's correct.
And you didn't know if any single other person at Aero Coach also held those views.
I do not know that. No.
Because you didn't interview anyone else from Aero Coach either, did you?
No, I did not.
You never interviewed Courtney White, true?
I read her deposition.
Sir, I'm not asking if you read her deposition. I'm asking if you interviewed her, and you didn't.
I did not interview her.
In fact, you never interviewed anyone who investigated this accident, did you?
That's right. I read some reports people made who investigated. I did not personally interview anyone.
Well, sir, we're going to talk more about those reports in a moment, but because you reviewed those reports, you know that this crash occurred on Interstate 20, right?
I do, yes.
You know the speed limit on I-20 is 80 miles per hour, don't you?
That sounds right.
You know that this accident occurred when Gary Winters crossed over the median and struck the bus.
That's true. That's true.
Now, you said a moment ago that when you performed this analysis, you looked at the bus.
Try to look at the pictures of the bus.
Well, that's right. So you only looked at photos, true?
That's correct.
You never went and examined the bus in person, did you?
That's also true.
Now, you reviewed the NTSB report on this accident, didn't you?
That's correct.
That's the National Transportation Safety Board.
That's right.
And you know the NTSB is an independent agency responsible for promoting highway safety, right?
Correct.
And they wrote a section in this report that they titled Probable Cause, didn't they?
That's also true.
And in that section, they included several causes of this accident.
That's true.
They mentioned the median system on the highway, right?
That's right.
They mentioned Gary Winters crossing over the median.
That's true.
They never once mentioned a single concern with the windows on Aero Coach's bus, did they?
That's right. They were focused on the cause of the accident, not the cause of Miss White's injuries.
Well, sir, they did examine some of the safety features on the bus, didn't they?
That's correct.
They looked at the seat belts, right?
That's true.
And they never once said that they had any concerns with the windows on the defendant's bus, did they?
That is not in the report. That's true.
Now, you know that this bus rolled onto its side during this accident, right?
That's accurate.
You did not see when the window shattered, did you?
I was not there.
You did not see what state the bus was in immediately after the accident?
I saw pictures of it, and I heard Miss White's testimony earlier, but I was not physically there. That's correct.
Let's take a look at one of those photos. I'm sharing with the witness what's already been entered as Exhibit 2. Mr. Murray, can you see Exhibit 2 on your screen?
I can't.
Permission to publish Exhibit 2 to the jury, Your Honor, that's been pre-admitted?
Permission is granted.
Yes, Your Honor. So Officer Jokel, Mr. Murray, it is dark outside in this photograph, isn't it?
Yes, it is dark in the photograph.
And you know this accident occurred in the middle of the afternoon,
I do know it occurred in the afternoon. That's right.
around 3 p.m.
That sounds right.
And this was in the middle of July, wasn't it?
The July 4th.
So you know that between the time of the accident and the time this photo was taken, at least a few hours passed.
That seems right since it's dark outside. I don't know what time it gets dark in Lone Star, but I assume at least 3 hours passed.
Okay, so you assume at least 3 hours passed between the accident and when this photo was taken.
Yes, when you have an accident like this, I mean, the investigation, getting the bus up is going to take a while.
You don't know what happened to this bus during that 3-hour period, do you?
Personally, no, I do not. I've read reports of people who came on the scene after and heard Miss White's testimony, but personally, no.
And sir, you can see in this photograph, the bus is actually being held up by 2 cranes, isn't it?
That looks accurate, yeah.
You don't know if those cranes caused any further damage to the bus, do you?
The cranes cause further damage? No, I do not know if the cranes cause further damage to the bus.
Thank you, sir. And you mentioned that your concern with this bus was the windows. You said one of the concerns was the size.
Yes, well, coupled with the non-glazing, but yes.
Sir, you know there aren't any federal regulations regarding window size, are there?
That's accurate.
There's no Lone Star standards regarding window size.
That's also accurate.
You cannot even tell me what the ideal dimensions for these windows would be.
You know, it's a specific situation that when it comes, regulations are generalities. And so, yes, I can tell you that if you're going to make large windows, if you're going to make the biggest windows in the industry, spend $87 and glaze them.
Mr. Murray, I'm looking for exact numbers here. You cannot tell me what the ideal dimensions for these windows would be.
I can tell you unglazed windows should be smaller than Airbus's windows. I cannot give you an exact diameter.
And you never even measured the windows on this bus, did you?
I looked at them and it's pretty obvious. I've looked at tons of buses and they're the largest windows in Aero. The defendant actually acknowledged this. So I did not take a tape measure to them. I didn't need to conduct my analysis.
Sir, I'm not asking whether they were the largest in the industry. I'm asking if you measured those windows, and you did not measure them, did you?
That's accurate.
Now you're saying that the windows should have been glazed in your opinion?
That's true.
There is no federal standard requiring glazed windows, is there?
That's also true.
There's no Lone Star standard requiring glazed windows.
That's correct.
Now you told us a moment ago that some companies do glaze their windows, right?
That's true.
So you're saying that now in 2021, some bus manufacturers glaze their windows.
I'm saying some bus manufacturers, both in 2014 and now, glaze their windows.
Sir, I'm looking for a name here. What bus company do you know of that glazed their windows back in 2014?
I don't have a name.
I'm looking for a number. How many bus companies can you tell us with certainty today that you know glazed their windows back in 2014?
A few. I cannot tell you an exact number.
Sir, you're saying you know a few glazed their windows back in 2014?
That's right.
You remember when you were deposed before coming to court, don't you?
I do.
You remember you promised to tell the truth?
I did.
Remember you promised to include all information that might be important for your conclusions?
I answered the questions that were asked. If I said that, then that's accurate.
Sir, you were specifically asked about the fact that some bus companies do glaze their windows, weren't you?
I believe so, yes.
And you never mentioned that you know Some manufacturers glazed their windows in 2014.
Objection, Your Honor. You're saying improper impeachment. May we be heard at sidebar?
You may.
Your Honor, defense counsel is attempting to impeach Mr. Murray with his prior statement. To do so, she needs to have him have the statement in front of him, have him lay the foundation that this copy he has is accurate. None of these steps have been followed, and thus at this point, this is an improper impeachment.
Ms. Kunkel?
Your Honor, it's an impeachment by omission. When he was deposed, he promised to include all important information, all relevant information, and he never once mentioned that these manufacturers glazed their windows in 2014.
Well, doesn't that depend on whether he omitted it? Doesn't that depend on whether he was asked the question? I think this line of question, I think this omission line of questioning has gone far enough.
Your Honor, am I permitted to just get an answer on the record for this question, or would you like me to move on?
I'd like for you to move on, please.
Yes, Your Honor. Now, Mr. Murray, you didn't run any tests to see what amount of force it would take to break the windows on Aero Coach's bus, did you?
Run any test? No, I did not.
You ran no tests to see how the windows would break in the event of an accident.
Other than comparing it to the previous crash, that is correct.
Well, sir, you don't know what kind of glazing they used on that other bus, do you?
I know it's glazing. There are several types of glazing, so I don't specifically call which type, but I do know they glazed the windows.
Sir, you don't know how much force was exerted during that other crash, do you?
I know that the bus rolled over, and these are similar sized buses, so the force is going to be similar when a bus of that size rolls over. Other than specific measurements from 1980, no, I do not.
Mr. Murray, I'm going to bring you back to my question. I'm going to ask you to answer. You do not know how much force was exerted on the windows in that other crash, do you?
I know it was similar to this crash.
Sir, you don't know how much force was exerted on the windows in this crash.
That's correct. I don't have a calculation.
You do not know how fast those vehicles were going in that crash back in 1980.
I do not know a specific speed.
You don't know how fast the vehicles were going in this case.
I don't think that is in the report. It's obviously fast enough to knock a bus over, but I do not know a specific speed.
Sir, you did not run any simulations or tests to see what would happen to glazed glass in the conditions of this accident.
Again, this accident is very similar to the accident previously, and in the industry, it's very common. What happens to glazed glass? It breaks but doesn't shatter.
Sir, I'm not asking about that previous accident. I'm asking about what you did to prepare for this case. Okay. You did not run any tests or simulations to see what would happen to glazed glass in the conditions of this accident.
I consider a test simulation comparing it to similar accidents. If you consider it an actual mathematical calculation or something, no, I did not do that.
Now, sir, you told us a minute ago that it is, quote, cheap to glaze windows.
That is correct.
You mentioned that $87 cost, right?
That's right.
You know that that's an annualized number, don't you?
I believe it's a per production. So when you produce a bus, it's going to be $87 to do the windows.
Well, you know that the NHTSA, they're the ones who came to that number, right?
It is in that report. That's correct.
And they said that it was an average incremental material cost of $87.
Can you bring that up? I don't recall one way or the other.
Sure. I'm sharing my screen with the witness. It's showing a portion of Exhibit 23. Mr. Murray, can you see Exhibit 23 on your screen? It should be page 11.
That's right.
It says right here that it's an average incremental material cost of $87.
That's right, but it doesn't say annual. So I agree it's an average incremental cost of $87, and maybe 86 for one bus, 88 for another, but that's the average price per bus.
Well, sir, you never ran any cost analysis on your own, did you?
It's reasonable in my industry to rely on a government entity like that.
Sir, I'm not asking what you think is reasonable. I'm asking if you performed your own cost analysis, and you didn't, did you?
I relied on the one we just saw.
Sir, I'm going to ask you to answer my question. You did not run your own cost analysis.
I did not.
You did not look at any of Aero Coach's financials, did you?
I did not look at Aero Coach's financials.
Thank you, sir. I have no further questions, Your Honor.
Any redirect, Mr. Matz?
Yes, Your Honor. Mr. Murray, defense counsel asked you some questions about how long glazing has been available. Now, that crash you were telling us about earlier, where the bus had glazed glass, what year was that from?
It's in the mid 1980s, I think 1987, but that's testing my memory a little bit.
Thank you, Mr. Murray. Nothing further, Your Honor.
All right, can this witness be excused?
Plaintiff has nothing further for this witness, so would ask that he be excused, Your Honor.
Any objection, counsel?
No, Your Honor, we have no objection.
All right. All right. So, counsel for the plaintiff?
Apologies, Your Honor. Some unmuting issues. The plaintiff rests our case in chief.
All right. Okay, are we ready? I see your smile. Does that mean we're not moving on to the first defense witness?
Your Honor, defense does have one mid-trial motion if you'd like to hear argument.
All right, let's hear your motion.
Defense moves for Rule 50 judgment as a matter of law. Viewing the evidence in the light most favorable to the plaintiff, no reasonable jury would have a sufficient basis to find for plaintiff because they failed to prove that Aero Coach had an economically feasible, safer alternative design at the time the bus left Aero Coach's possession in 2014. Today, Lynn Murray spoke about glazed windows as an alternative, but the only evidence on economic feasibility we heard was from a proposed rule that was ultimately withdrawn. The jury heard no evidence about Aero Coach's cost-benefit analysis or financial reports that would speak to the feasibility of making this change. Lynn Murray's testimony about the isolated cost of $87 to glaze a single bus cannot help the jury determine whether it was feasible for Aero Coach to glaze their entire fleet of buses. Mr. Murray himself told us that he did not review any Aero Coach financial reports to help the jury decide this issue. So for this reason, we'd ask the court to grant our motion.
Response?
Yes, Your Honor. We have established such that a reasonable juror could find, viewing the facts in the light most favorable to the plaintiff, that there was a safer alternative design. Now, like opposing counsel said, Mr. Murray said glazing is that safer alternative design. It's been available since the 1980s, and the federal government studied the issue and said for the average bus manufacturer, it had only cost them $87 more per bus. Now, a reasonable juror could absolutely find that $87 number makes it so that it was economically feasible for the defendant to use glazing. Thus, our claim should not be dismissed under Rule 50.
All right, I'm going to overrule the motion.
Yes, Your Honor. May we request a time check at this point in trial?
Mr. Bailiff?
Yes, one moment. So the plaintiff has 29 minutes, 19 seconds remaining, and the defense has 33 minutes, 56 seconds remaining.
All right, so is the defense ready to proceed?
Yes, Your Honor. Defense is prepared to call our first witness.
And will that be you or Ms. Kunkel?
That will be me, Your Honor, unless you wanted us to take any kind of recess just to give our jurors a break or anything like that, but we're fine proceeding right through if you'd like.
Well, it does appear to be a fairly old jury, but unless I get a text or an email requesting a short recess, I think we'll just proceed.
Yes, Your Honor, we call Officer Jokel.
All right.
May I proceed?
You may proceed.
Thank you. Good afternoon, sir. Please introduce yourself to the members of the jury.
Hi, I am Officer Taylor Jokel.
You said that you're an officer. What force do you work for?
So I work for the Lone Star Department of Public Safety.
How long have you been working for Lone Star DPS?
Quite a while, I think about 15 years now.
And did you ever go to school before you joined DPS?
Yeah, so I got my associates from my local community college. Then I went to state, got a bachelor's degree from there, and then spent some time at the academy pursuing further education there.
You said you got your associates and your bachelor's. What were those in?
I believe criminal justice.
And you said you also had some training at DPS. So what did that training entail?
It was a lot of just general training that they give their officers, but especially in regards to motor vehicle accidents.
Have you investigated motor vehicle accidents in your time as a DPS officer?
I have quite a few.
You say quite a few. Can you estimate how many?
I'd estimate around 250.
All right, so I'd like to focus on the accident that occurred on July 4th of 2019. Did you investigate that accident on I-20?
I did.
What's the typical process that you follow when you investigate an accident?
Yeah, so typically I'll get a call that there's been an accident. I make my way to the scene of the accident. I survey sort of what happened. I talk to anybody there about figuring out what all happened. And then once I've collected information, I start writing a report.
Did you follow that process in this case?
I did.
Did you write a report like you mentioned?
I did, yes.
I'm sharing with the witness Exhibit 5. Officer Joko, can you see Exhibit 5 on your screen?
I can, yes.
What are we looking at?
So this is the report that I created for the July 4th, 2019 accident.
Is it a fair and accurate copy of that report?
It appears to be yes.
And is it a regular practice of your office to keep reports like these for accidents?
Yes.
Your Honor, we offer Exhibit 5 into evidence.
Any objection?
None, Your Honor.
Admitted.
Yes, Your Honor. Permission to publish to the jury?
Yes.
Yes,
So
Your Honor.
that's granted.
Thank you. Officer Joko, I'd like to talk about some portions of this report. At the top here, does it indicate what highway the accident took place on?
Yeah, it took place on the westbound lanes of the I-20 near Barstow.
What's the speed limit on I-20?
It's 80.
Let's talk about the vehicles involved.
Yeah, it
This first vehicle here on the report, what kind of vehicle was that?
was a 2014 Aero Coach View bus.
Who was operating that bus?
A person by the name of Padden Holt.
What company was Mr. Holt working for that day?
Big View Tours LLC.
So was Aero Coach operating this bus on July 4th?
No,
All right, let's look at the second vehicle. What kind of car was that?
it's a 2015 green Chevy Suburban.
Who was driving that vehicle?
Gary Winters.
And what did his license plate say on that SUV?
It said free grass.
Now I see here, sir, that there's an alcohol and drug analysis result. What level of THC was in Mr. Winters' system?
It's 2.8 nanograms per milliliter.
Thank you, sir. Now, did you also review the NTSB report for this accident before coming to court?
I did.
Would you recognize it if I showed it to you?
I would.
I'm sharing with the witness what's already been admitted as Exhibit 8. Officer, can you see Exhibit 8 on your screen?
I can, yes.
I'd like to focus on this third page, this probable cause section here. What
Sure.
did they say about whether Mr. Winters could have been impaired by THC while he was driving this vehicle?
It said that he was potentially impaired.
Thank you. Now, I'd like to focus on the lead up to the accident. Were you able to determine what was the first event in the series of events that caused this crash?
Yes, I think so.
What was it?
So there appears to have been a downpour of rain, and there's two westbound lanes on I-20, and after this downpour of rain, a Prius in the right lane of the westbound lanes stopped, and then cars started stopping behind him because there was a car stopped in the middle of the road.
Sir, would a diagram help you explain what happened next in this series of events for the accident?
Yeah, I think so.
Your Honor, if we were in a physical courtroom, this is typically the point where I would have Officer Jokel step down and join me in the well and help me walk through this diagram with the jury. May I now share my screen and assume that the jury can follow along while we go through this diagram?
I think that would be a good idea.
Yes, Your Honor. Officer Jokel, can you see the diagram on your screen?
I can.
Honor, point of order.
Yes.
May I speak
Is
outside?
is that an objection or you said point of order?
Yes, Your Honor, there's just something I want to call to Your Honor's attention before we proceed further with the diagram.
All right.
Outside the earshot of the jury, Your Honor.
Okay.
Your Honor, the parties met and conferred pre-trial and agreed that if this demonstrative were to be shown to the jury, that Your Honor should issue a limiting instruction to the jury that none of the images depicted in the demonstrative are the actual vehicles that were involved in the accident, that they're mere approximations, and that nothing is to scale.
Ms. Kunkel, is that right?
Yes, Your Honor, that's perfectly fine with us. We're just showing the general paths these vehicles took.
All right. And so let's constructively assume that the jury has been so given that limiting instruction.
Thank
Yes,
you.
Your Honor. May I proceed with Officer Jokel?
You may.
Thank you. Officer, I'd like to start off by labeling a few things on this diagram.
Sure.
This bus on the top right-hand side, what company was operating that bus?
Big View Tours LLC.
All right, and that red SUV on the bottom left of the image here, who was operating that?
Mr. Winters.
What direction were each of these vehicles heading initially?
So the Big View Tours bus was going in the westbound lanes. It was in the right lane of the westbound lanes. And the SUV was traveling eastbound on the other side of I-20 in the left lane of the eastbound lanes.
Do these arrows now show the directions you just described?
They do.
All right, you just told us a moment ago how the rain started pouring down, these cars started piling up. What happened when the bus came upon those cars?
So instead of braking, the bus swerved into the left lane of the westbound lanes.
Sir, in the course of your investigation, did you learn why the bus driver wasn't able to brake?
Yeah, I received some information that he might have been distracted.
Were you present for Ms. White's testimony here today?
I was.
Did you hear her say that the driver was making eye contact with another passenger?
I did.
Did that contribute to your conclusion regarding the driver's distraction?
It did.
All right, so you said that he wasn't able to brake on time. What was Gary Winters' SUV doing at that point?
So Gary Winters' SUV crossed the median and ended up in the left westbound lane of I-20.
And sir, you were describing what the bus had to do to avoid those cars. Can you tell us that again?
Yeah, so in order to avoid the stopped cars in front of it, the bus swerved into the left-hand lane around the backmost car.
Did Gary Winters cross all the way over that median?
He almost made it there, and then he ran into the bus.
Sir, does this diagram now generally show the path that bus and Gary Winters' SUV took?
Yeah, it does.
Your Honor, we asked to preserve this last slide for use in closing argument. We can mark it as Exhibit 29 if you'd like. That'd be the next one in the packet.
Any objection?
No, Your Honor, and in this jurisdiction, demonstratives are typically preserved in this manner for closing argument.
Very good.
Thank you, Your Honor. Officer Jokel, you told us that Gary Winters crossed this median and hit the bus. What happened to the bus after he hit it?
Well, the bus tipped over and went onto its side until it came to a halt.
What evidence did you find that the windows on this bus were shattered before Gary Winters slammed into it?
I didn't find any.
What evidence did you find that Courtney White was injured before Gary Winters slammed into the bus?
I didn't find any.
Without Gary Winters, does this accident happen?
No.
Thank you. I have no further questions, Your Honor.
Cross-examination? Ms.
Yes,
Diamond?
Your Honor. May I proceed?
You may.
Good afternoon, officer.
Hi.
I want to start by talking about your investigation in this case. You'd
Sure.
agree that when you're investigating an accident, it's important to be thorough.
Yeah,
Because if you're not thorough, that can lead to mistakes.
yeah.
When you arrived at the scene of this accident, you had a tape measure with you, right?
I can't remember. I think I might have.
You took no measurements.
I mean, no, I didn't.
When you arrived at the scene, you had a camera.
I can't remember.
What you do remember is that you took no photographs, right?
Yeah, I didn't take any photographs.
You had a pen,
I probably did.
but you didn't draw any diagrams of the scene.
No, I didn't.
You never drew a diagram of how this accident happened.
No, I did not.
That diagram you walked us through on direct examination, you didn't create that.
I did not.
You don't know who created that diagram.
I think the attorneys for the defense did.
And the first time you ever saw that diagram was when defense counsel showed it to you just before the trial today, right?
Yeah,
Let's talk about the accident reconstruction that you performed then.
sure.
When you reconstruct an accident, you look at what happens when two objects collide.
Sometimes, yeah.
To do that, you need to know a few variables,
Sure.
like the speed of the object.
Yeah,
But officer, you didn't calculate the speed the defendant's bus was traveling,
I did not.
or the speed the SUV was traveling.
No, I wasn't able to do that.
Officer, it's not that you weren't able to do it. You didn't even try to calculate the vehicle's speed, right?
No, I didn't.
Then let's talk about seatbelts. You're an officer with the Department of Public Safety,
Yes, I am.
a patrol officer.
Yes.
So part of your job is writing tickets.
Yeah,
If someone driving a car isn't wearing a seatbelt, you ticket them.
sometimes, yeah.
If a passenger in a car isn't wearing a seatbelt, you ticket them.
Can you repeat your question again? Sorry.
If a passenger in a car isn't wearing a seatbelt, you ticket them, right?
Yeah,
But you wouldn't ticket a passenger on a bus for not wearing a seatbelt, would you?
I don't think I've ever done that before.
That's right. In your 15-year career, you have never ticketed a bus passenger for not wearing a seatbelt.
Yeah, I don't think I have.
Thank you, officer. You have no further questions.
Redirect?
Yes, Your Honor, may I begin?
Yes.
Officer, counsel was asking you some questions about what you did or did not do at the scene. Did you interview Miss White when you performed your investigation?
I know I talked to her at some point. I can't remember if I talked to her at the scene of the investigation or not.
And did you hear her testify today?
I did.
What did Miss White say about the cars that stopped up ahead?
She said that there were cars stopped up ahead and the driver of her bus swerved out of the way of them.
What did Miss White say that Gary Winters did?
That he crossed into that median and he collided with that bus.
Thank you, sir. I have no further questions, Your Honor. May Officer Jokel be excused?
Any objection?
No, Your Honor.
He may be excused.
Your Honor, defense calls Dr. Andy Zielinski. May I proceed?
You may proceed.
Good afternoon, sir. Would you please introduce yourself to the jury?
Yes, my name is Andrew Zielinski, PhD.
What do you do for a living?
I am a mechanical engineer and I do design and consulting work for companies that make large vehicles.
Can you tell us a bit about your background in engineering?
Sure. Educationally, I went to Southwestern University, which has a renowned engineering program. From there, I was accepted into Princeton University, where I got my master's and then later my doctorate. and I then went to my present job doing design and consulting work.
Can you tell us a little bit more about the kind of design and consulting work you do at this firm?
Sure. So the design side, that's basically where my engineering expertise is most focused. We assist in the design and development of like large agricultural trailers and specialty type vehicles. Now, the consulting side is more geared towards doing regulatory compliance work, making sure that the vehicles that we design or that we consult on are compliant with all the federal standards.
Now, sir, do you also consult with manufacturers of over-the-road vehicles as well?
Yes, I mean, all of these would technically be, well, a lot of the vehicles we work on are qualify as over-the-road vehicles, yes.
Let's break down what kinds of vehicles you've worked with. You
All right.
mentioned specialty vehicles. Can you tell us what specialty vehicles might include?
Sure, that could be things like trolleys or even school buses, basically, large vehicles of that nature.
You also mentioned over-the-road vehicles. Can that include buses?
Yes, an over-the-road vehicle is basically just an elevated passenger deck located over a baggage compartment. So anything of that nature will qualify as an over-the-road vehicle, and that's one of the things we work on in our design and consulting firm.
Did you review a photo of the AeroCoach bus in this case?
I did review that photograph.
Does the bus in this case match the description of an over-the-road bus?
Yes.
Yes, sir. Have you done any other design work as a mechanical engineer?
Yes, I've done some design work on things, like I said, some agricultural vehicles and things of that nature.
Does that work relate to the cabin, the interior cabin?
Generally, yeah. I mean, one of the things I like to focus on, or one of the things I focus on the most, is safety. And so one of the areas we focus in on pretty intensely is compartment safety.
So we're going to get back to compartment safety in just a few minutes.
Mhm.
First, have you done any accident investigation work in your career?
I have done accident investigation work.
Did you help investigate the accident in today's case?
I did, as well as one other accident involving a bus.
Can you tell us what did you review to help form your conclusions in this case?
Well, obviously the DPS report, the NTSB investigation, as well as the applicable federal standards and some internal documents from Aerobus.
Can you tell us what kind of federal standards applied to this case?
Well, the federal standards applicable to most large vehicles traveling in interstate commerce are promulgated by the NHTSA and its related agencies.
Are those all related to safety?
Yes, they're all safety regulations.
Dr. Zielinski, were you able to come to conclusions about the safety of the AeroCoach bus involved in this accident?
Yes.
In coming to those conclusions, did you use reliable principles and methods used by other mechanical engineers?
That's the way it's done, yeah.
Did you apply those principles and methods to the facts of this case?
I did.
And do you believe your testimony will be helpful to the jury to help understand the facts of this case?
I sure do.
Now, Sarah, I'd like to talk about some of the design features on this bus. First, in your opinion, was the design of this bus unreasonably dangerous?
No, there's nothing about the design of this bus that was unreasonably dangerous.
Let's talk about the seat design. In your opinion, were the seats on this bus designed to achieve safety?
Yes, like I said, one of the areas I focus on the most is the safety of compartments of these vehicles. And one of the things that buses generally use to enhance safety for their passengers is what we call compartmentalization. Now, that has to do with the space between seats as well as the height of the backrests of seats. This bus was designed for compartmentalization. So if it wasn't an accident or when a bus is in an accident, you have less space for the body to move and therefore gain velocity. And so you have this kind of like safety cocoon created by the distance between the seats.
Sir, have you been in court throughout this trial?
I have.
Did you hear Courtney White testify about the space around her seat, specifically the space she had between her seat in front of her and her knees?
Yeah, I believe she said it was uncomfortable.
Now, does that description support this concept of compartmentalization?
Yeah, if she didn't have a bunch of room for her knees, then it indicates to me that there was a sufficiently small space between the seats.
Now, where does a passenger have to be in order for compartmentalization to work?
Seated.
And
They
where
have
was
to
the
be in their
plaintiff?
seat.
Oh, excuse me, sir. You have to be in their seat. Do you know where the plaintiff was when this accident occurred?
I believe she said she was standing up next to her seat, perhaps, or either that or turned around in her seat, one of the two.
But you understand that she was standing up, sir?
Yes.
Now, did you hear Courtney White also testify that she wasn't wearing a seatbelt?
Yes.
Did Aerocoach provide seatbelts on its bus?
Yes, there were lap seatbelts.
Now, are there any federal regulations that set the standard for seatbelts on this kind of a motor coach?
On this type of motor coach, yes, there are now standards that require type 2 type seatbelts, but those standards were promulgated after this bus was designed, manufactured, and sold.
Now, in 2014, when this bus was made, did they comply with the applicable seatbelt regulations?
Yes.
Doctor, I'd like to move now to talk about the windows on this bus. Are there any regulations about bus window size?
No, there are no state or federal regulations regarding the size of windows on a bus.
Are there any regulations about window glazing on the bus?
There are no federal regulations dictating anything about windows on the buses.
Is there a uniform practice related to window glazing in the bus industry?
No, there is not.
Now, sir, you've been in court today. Did you hear Lynn Murray identify any federal or Lone Star regulation that Aerocoach violated?
No, I did not hear him testify as to any standard that was violated.
In your opinion, were the windows on this bus unreasonable?
No, the windows on the bus were not unreasonably dangerous.
Sir, I'd like to talk about the bus roof. Are there regulations related to the roof of a bus?
Yes, there are regulations regarding the strength of the roofs of motor coaches, and those regulations are geared towards preventing the roof from intruding into the passenger compartment and causing injury in the event of a rollover.
Can that also be referred to as roof crushing?
Yes.
Now, in your review of this case, did the roof crush?
No, it seemed to have tilted slightly, but it didn't crush.
You say it tilted slightly. Can you tell us more about that?
Sure. Instead of crushing down into the passenger compartment, it did what it was designed to do and I guess distributed the weight more evenly across its top, causing a slight bend and not a full crush.
Does the regulation on roof crushing say anything about roof tilting, roof twisting, anything like that?
No, as I indicated earlier, it's more geared towards preventing the roof from crushing down into the passenger compartment and killing people.
Thank you, sir. Now, did you hear Lynn Murray testify that he took no test to see what amount of force would be required to break glazed windows?
Yes. I mean, I did hear that testimony.
And in your opinion, can glazed glass shatter?
It can, yeah.
Is it possible that in this case, the windows on the bus shattered when the bus rolled over?
That is a distinct possibility, yes.
Is it possible that glazed windows would have shattered in the same way?
It is.
Is it possible that glazed windows could have popped out?
Yes, and in fact, there was once a proposed rule about glazing windows, and that rule was ultimately rejected because sometimes glazed windows fall out entirely instead of partially, and it creates a situation where people can be ejected from the bus. Now, being ejected from the bus is actually the way most people die in bus crashes. So they thought, hey, you know, if we glaze the windows, there's a likelihood the window will fall out entirely and cause this ejection type of harm potential. And if we don't leave it in there, then there's a possibility that the ejection won't be an issue. So it was kind of a wash and they rejected the rule.
So that rule, it never went forward. It was withdrawn, correct?
That is correct.
And Sir Courtney White, she wasn't ejected from this bus, was she?
She was not.
Now, in your experience as a mechanical engineer, was the design of this bus safe?
Yes.
Thank you, doctor. No further questions.
Cross-examination.
Yes, Your Honor.
All right, you may proceed.
Good afternoon, Dr. Zielinski.
Is it? Yes, it is. So good afternoon.
I want to talk about your qualifications when it comes to bus design. You have experience designing trucks.
Yes.
You have experience designing tractors.
Yes.
You have never designed a bus.
I've not designed a bus, no, but the principles of physics involved in safety and design of large vehicles that travel in interstate commerce don't really change. So,
Well, Dr. Zielinski, I'm not asking you about the principles of physics. I'm just asking about what you've done. And you've never designed a bus, right?
no.
I want to talk about some of the aspects of the defendant's bus that you were just telling us on direct examination. Now, on direct, you said that you thought the defendant's bus had a safe roof, right?
Yes.
If shards of glass are flying throughout the cabin, a safe roof can't shield passengers, can it?
From the glass?
From the glass, right?
No.
On direct, you said that the defendant's bus had safe seatbelts, right?
Yes.
If glass is flying throughout the cabin, a seatbelt can't shield passengers from that glass, can it?
Well, it can keep you stationary so you don't move through as much broken glass. Yeah.
Dr.
I mean,
Zielinski-
I don't know that I can agree with you on that.
Dr. Zielinski, I'm not asking if it can keep you stationary. I'm asking if that seatbelt's going to block glass from your face. And it's not, is it?
I suppose the seatbelt won't, no.
Let's talk about the thoroughness of your work in this case.
All
Now,
right.
you agree that when evaluating a design, it's important to be thorough, right?
Sure,
If you're not thorough, it could lead to mistakes.
it can.
You concluded that the defendant's design is safe.
I did.
You concluded that design is safe without looking at any blueprints of the design.
I did not look at the blueprint schematics of this bus, no.
Without taking any measurements of the design.
Yes, like Mr. Murray, I did not take any measurements of this bus.
Dr. Zielinski, I'm not asking you about what you think Mr. Murray did. I'm asking you about what you did. And you took no measurements, right?
No, and it's not necessary to do what people like me and Mr. Murray do.
Dr. Zielinski, you concluded this design is safe without doing any research on how many people have been injured on the defendant's buses.
No.
Let's talk about the defendant's buses. Now, this is an Aero Coach View bus, right?
Yes.
You've never seen bigger windows on a bus.
There's some pretty big windows.
Well, not just pretty big, they are the biggest you have ever seen on a bus, right, Dr. Zielinski?
Yeah, I do think they're the biggest windows in the market. They provide excellent views.
Let's talk about the strength of those windows. You'd agree, none of the defendant's windows were laminated, right?
That's correct.
None of the defendant's windows were treated with protective chemicals.
No, they weren't tempered.
None of the defendant's windows were treated with advanced glazing.
That's true.
None of the defendant's windows used any glazing, right?
Like I said, no, they didn't use any glazing.
You're familiar with some internal memos that the defendant's executive vice president wrote, right?
Yes, I've read those memos.
You've got Exhibit 15 up here on the screen. Now, in this memo, the defendant's executive vice president says that unglazed glass tends to break, right?
Yes.
They say that unglazed glass tends to break into shards.
Yeah, that's what they said.
The defendant's executive vice president says that unglazed glass is admittedly dangerous.
Sure, yeah.
Well, let's talk about why that matters. Now, in your work for this case, you reviewed some research by the National Highway Transportation Safety Administration, right?
That's correct.
And you learned about a crash that's similar to the one in this case, right?
Yes, that was in the material.
In that crash, there was a bus, right?
Yes.
Like this case, it was on a highway.
I'm sorry, it was a motor coach, but yes.
Like this case, it was on a highway, right?
Yes,
Like this case, it rolled over.
it did.
But unlike this case, that bus had glazed windows, right?
That's right.
None of those buses' glazed windows shattered when it rolled over, did they?
I believe that's correct.
You're not aware of any crash in the 33 years since the crash we're talking about where a bus with glazed windows rolled over and they shattered, are you?
You know, I'd have to think real hard about that, but I can't think any off the top of my head, no.
You can't think of any crash where a bus with glazed windows has shattered.
I'm sorry you lagged there for a second.
That's all right, Dr. Zielinski. I was just saying you can't think of any crash where glazed windows on a bus have shattered, right?
Not off the top of my head, no.
When the defendant's bus rolled over, their unglazed windows shattered, right?
Yeah, but you'll note that the roof stayed up and no one died because they were decapitated by a crushed roof.
Dr. Zielinski, we're not talking about the roof or anyone being decapitated. We're talking about the windows.
Yeah, the windows broke out, I agree.
When the defendant's bus crashed, Miss White was showered with the defendant's unglazed glass, right?
Yeah, she, I guess, did come into contact with some pieces of broken glass.
Thank you, Dr. Zielinski. Pass the witness.
May redirect?
Yes, Your Honor. Dr. Zielinski, you were just asked, you can't think of any bus crash where glazed windows have shattered. How many bus accidents have you investigated prior to this one?
Well, this would be my second.
Sir, you also testified about AeroCoach's internal memo. Did that memo from AeroCoach give you any sense of why they didn't add glazing to their glass?
You know, they did discuss that there were costs associated with it, and that's something that we all have to do. If you're going to have an enormous cost, you have to think about how likely it is that engaging in that cost is going to avoid a harm. Now, this type of accident is incredibly rare. Moreover, it's incredibly rare for people to be injured by broken glass in a bus accident. So if you're looking at this large cost on one hand and a minuscule probability of this type of accident occurring, then it just makes sense that you would avoid that cost.
Thank you, sir. Is there any regulation that applied to this bus in 2014 that AeroCoach failed to meet or follow?
No, this bus was in absolute compliance with all federal and state regulations in 2014 when it was manufactured and left the control of Aerobus.
Thank you, Dr. Zielinski. I have no further questions. Your Honor, may the witness be excused?
The witness may be excused.
Your Honor, with that, defense rests our case and renews our Rule 50 motion on arguments previously stated.
Same ruling.
Yes, Your Honor.
So plaintiffs, do you close?
Yes, Your Honor. If we could get a time check from the bailiff on how much time we have remaining for closing.
We will in just a moment. Do you close? But you have closed.
Oh, yes, we rest our case in chief, Your Honor.
And the defense, have you closed? Are you closing? You've rested. Are you now closing?
My co-counsel will give a closing argument. Yes, sir.
Okay. All right. Let's get a time check.
Yes, Your Honor. Plaintiff still has 19 minutes, 27 seconds remaining, and the defense has 12 minutes, 20 seconds remaining.
All right. I will allow the plaintiffs to reserve up to 3 minutes for rebuttal if you so choose. You don't have to. And would both sides like I obviously can't see what's in front of you. Do you have a timer? Would you like a something from the bailiff to hold? I don't know if he has a piece of paper that he can hold up when you have a minute left, or
If you could just turn on his camera and do how many minutes in fingers, that'd be great, Your Honor.
Can you do that, Mr. Bailiff?
Yes, Your Honor, I can. Would you prefer just 1 or 2 minute warnings, or how many minutes?
I'll let them have a one warning, and I'll let them choose whether it's 1, 2, 3 minutes, whatever.
Your Honor, I actually have a timer on my end, so I will not need any warning whenever I'm getting low on time. I'll be keeping track of that.
All right.
And Bailiff, if I could just get a warning at 3 minutes, that'd be great.
Okay, are we ready to proceed with closing?
Your Honor, plaintiff's ready to proceed to closing.
And Ms. Kunkel, how about you?
Yes, Your Honor, we're prepared.
All right, let's hear from the plaintiff.
Your Honor, before I begin, may we display exhibits that were admitted throughout trial and portions of the jury instructions during our closing?
You may.
Thank you. When Miss White picked the defendant's bus because of its windows, she thought that they'd give her a better view. But what she didn't know was that her view would be of those windows shattering. She watched as glass flew throughout the bus, showered her body, sliced her flesh. Members of the jury, Miss White was injured because the defendant's windows were too big, too weak, and too cheap. As the plaintiff, we had the burden today. We had to prove more likely than not that the defendant's defective design was a contributing cause of Miss White's injuries. We met that burden with 3 simple facts. A bus needs to be designed to keep passengers safe in a crash. The defendant's was not. And that design defect caused Miss White's injuries. So let's take those one at a time. Fact number 1. A bus needs to be designed to keep passengers safe in a crash. Now, the defense spent a lot of time today pointing the finger at others. Gary Winters, he drove over the median. The bus driver was distracted. Miss White, she wasn't wearing her seatbelt. All true. But it misses the point. Because a safe bus design plans for these events, plans for the inevitable. Now, when we evaluate whether a product is defective, we have to consider how it's used. How are buses used? Well, they're driven on the highway, where high-speed collisions are just inevitable. How are buses used by passengers? Well, you heard from Ms. White today, most of the passengers on that bus, they weren't wearing a seatbelt. You heard from Officer Jekyll today, he wouldn't even ticket someone for not wearing a seatbelt on a bus. Those passengers, they're not going to put one on a bus. So most of those defenses aren't actually defenses at all. They're excuses. The defendant couldn't just design a bus that's safe unless it gets in a crash. It had to be reasonably safe when it gets in a crash. So how can a bus company do that? Well, Mr. Murray told us it's all about those windows. They can crack, but they can't shatter. Because if they shatter, people could get ejected. People can get cut. That brings us to fact number 2. The defendant's windows were defectively designed. Now, a design is defective if it's unreasonably dangerous. We know that these windows were unreasonably dangerous because the company that makes them admitted they are. Literally. Unglazed windows are admittedly dangerous. Now, the defense has tried to say today, well, this is just an internal memo. It's just a draft. Exactly. When the defendant is talking to the federal government, oh, our windows, they're safe. When the defense is here in court talking to you, oh, our windows, they're safe. But privately, when they're not being sued, our windows tend to break into shards. Our windows are admittedly dangerous. So what made these windows so dangerous? Well, I want you to imagine that we're trying to design the most dangerous windows possible. The windows that are most likely to shatter in a crash. What would those look like? Well, we'd leave them completely unlaminated, untreated with protective chemicals, no regular glazing, no advanced glazing, no any glazing. And since we know the bigger a window is, the more likely it'll shatter, we'd make these windows big, the biggest in the industry. In other words, these windows would look like this. Like this. Throughout all of today's trial, you didn't hear one property, not one aspect of the defendant's windows that makes them less likely to shatter. Now, the defense, they've tried to say today, well, there's no industry standard. But on this point, they want to have it both ways. On glazing, they say, well, there's some buses that don't use glazed windows. But on the size of their windows, they say, ignore the industry standard. Ignore that we have the biggest windows in the industry. So then the defendant said, well, our windows, they don't violate any statute. Right. These windows didn't break any law, they just break. The question today isn't whether the defendant's windows committed a crime, it's whether their windows are unreasonably dangerous. And if you're going to build windows that are unusually likely to shatter because of their size, you've got to use stronger glass. They didn't. So then the defense told you, well, Dr. Zielinski, he disagrees. He thinks our windows are safe. Okay, so let's compare experts. Our expert designs buses. Theirs designs tractors. You don't see a lot of tractors driving on the highway. You don't see a lot of tractors getting into high-speed collisions. In fact, you don't see a lot of tractors with windows. The only expert you heard from who designs buses told you that the defendant's bus design is defective. Finally, the defense said, well, we've got other things that are good. We've got safe seatbelts. We've got safe roofs. Members of the jury, Ms. White wasn't injured by a seatbelt or by a roof. And neither of those things would have protected her. You heard from Dr. Zielinski, a seatbelt can't shield you when glass is flying throughout the bus. The roof can't shield you when glass is showering your face. Just because the defendant had some safe things on their bus does not mean that their windows are not defective. Does not mean that their windows are not unreasonably dangerous. And there's one other thing that makes those windows so dangerous. Now today we had to prove that there was a safer alternative design. That safer alternative is glazing. Glazing significantly reduces the risk that windows will shatter. Glazing doesn't impair utility. We didn't hear any evidence that it makes windows foggier or harder to clean. And glazing was economically feasible. It would have cost just $87. That's not just for one window, that is for all of them. Now, the defense might come up here in a second. They might say, well, $87, that sounds low, but think how many buses we make. The number would be bigger. Members of the jury, it's common sense. A bus costs a lot more than $87. And adding just $87 more to make sure those windows are safe was economically feasible. The windows were too big, too weak, and too cheap. The defendant's windows were unreasonably dangerous. Fact number 3, that design defect caused Miss White's injuries. Now, if the defendant had designed safe windows, they would have looked like this. Instead, they looked like this. The glass from those windows is completely gone. And we know where it went. Flying throughout the cabin, showering Miss White, slicing her legs, her shoulders, her face. And every shard of the defendant's glass that cut Miss White was unlaminated, untreated with protective chemicals, completely unglazed. And if you're wondering to yourself, wait, how was there enough glass to cut her from head to toe? Remember, these were the biggest windows in the industry. This is the jury verdict form. Question 1. The design defect is the defendant's windows, which were unreasonably and admittedly dangerous. Now, we had to prove that that defect was a producing cause of Miss White's injuries, that Miss White wouldn't have been injured but for that defect. Now, when the defense comes up here to talk to you in a minute, they might try to tell you, well, glazing, it just wouldn't have made a difference. Glazed glass is glass, it can shatter too. But we know that that's not true. Because in 1988, a bus with glazed windows was in a crash just like this one. It was on a highway, in a collision, and it rolled over. But none, not one of those glazed windows shattered. Not one of the passengers on that bus was cut with shards of unglazed glass. We know that if the defendant glazes those windows, they don't shatter. And if they don't shatter, Miss White doesn't get cut. You can write yes for question 1. And that brings us to question 2. Was anyone else's negligence the cause of Miss White's injuries? And here, the defense has the burden. Now, we acknowledge that Gary Winters was negligent, but the defense had to prove that his negligence was the proximate cause of Miss White's injuries, that it was foreseeable if he hit the bus, Miss White would be cut by glass. Now, it was foreseeable that she might hit her head, foreseeable that she might break some bones, but it was unforeseeable that a bus company would still be using unglazed glass today. Glazed glass has been available for 30 years. It's been protecting passengers for 30 years. Mr. Winters may have caused this crash, but it was the defendant who caused Miss White's injuries. You can write no next to Mr. Winter's name. And that just leaves us with Miss White. And Miss White just wasn't negligent. The judge is going to instruct you that negligence involves the ordinary person standard. What an ordinary person would do, or failing to do what an ordinary person would in the same or similar circumstances. There's a jury. The ordinary person doesn't wear a seatbelt on a bus. You heard that only one person was wearing a seatbelt on the bus in today's case. You heard from Officer Jekyll, I ticket people for not wearing a seatbelt in a car, but never on a bus. And there's another problem with the defense's theory. Because no matter what we think about Miss White's decision to not wear a seatbelt, it wasn't the cause of her injuries. Dr. Zielinski told you, a seatbelt cannot shield your face from a shower of shards of broken glass. You can write no next to Miss White's name. She didn't cause her own injuries. And if those are your answers, you're done. The defense, I told you at the beginning of today's trial that this accident was just out of the defendant's control. And that's true. But when something's out of your control, you got to do what you can to protect people from it. They couldn't control whether Mr. Winters came across the median, but they sure could control what windows they used. They could control whether those windows were glazed, control whether those windows were safe. For just $87, Miss White could have been protected. $87, and the defendant could have had glass that is proven to keep passengers safe in a crash. But they didn't. We ask that you find the defendant liable because their windows were too big, too weak, and too cheap. Thank you.
Before we get started, Ms. Kunkel, Mr. Bailiff, as I see it, he's got about 3.5 or 4 minutes left. I told him he could have 3 minutes on rebuttal. Does he have 3 minutes left or not?
Yes, Your Honor. He has 3 minutes and 4 seconds.
Pretty good timing. All right. Well, you'll let us know when he comes back if he chooses to make a rebuttal. All right, Ms. Kunkel, I think you are ready to proceed, and you have a timer, and you have 12 minutes.
Yes, Your Honor. Thank you. Out of control. Aero Coach could not stop Gary Winters from hurtling across that median and striking the bus. They could not control whether Courtney would sit down or buckle up. Ultimately, it was these factors that caused Courtney's injuries. It was out of Aero Coach's control. See, Aero Coach Bus Works designs buses that are safe for passengers. Every single thing that Aero Coach does before that bus leaves the manufacturing plant, it's on Aero Coach. But the second that that bus is bought by a company like Big View Tours, the second that it's driven by someone who does not work for Aero Coach, it's out of their control. The bus in this case left Aero Coach in 2014. From that point on, there was nothing Aero Coach could do to prevent what other people would do to it. They could not control what happened in 2019. When Gary Winters woke up on July 4th, 2019, he made some choices. He chose to get behind the wheel of his car. He chose to start driving eastbound on I-20, driving up to 80 miles per hour with THC in his system. At around the same time, Courtney White was boarding this bus. She was walking down the aisles, saw those seats close together, all the seat belts available. She picked a seat, sat down, and chose not to buckle up. The bus took off westbound down that same highway where Gary Winters was already heading east. And as they're traveling down I-20, Courtney made another choice. She chose to stand up. This is where Gary and Courtney's paths cross. They don't know it yet, but they are on a collision course. It's about 3 p.m. The rain starts pouring down. Gary Winters is still traveling down that highway. Takes his eyes off the road in front of him. He's distracted. The next thing that we know he sees is that tour bus getting bigger and bigger in his windshield because he has crossed over that median, driven all the way across the grass, and he's getting into those westbound lanes of traffic. He slammed into that bus. That bus where Courtney White is still standing. Before she's knocked into a pile of glass by the force of Gary's car. He made a dangerous mistake, one that caused this accident and injured the plaintiff. Gary Winters was out of control. In 2019, it was all out of control, and that means it was not the fault of AeroCoach. See, today it was the plaintiff who filed this lawsuit, and the judge will tell you that means they had the burden of proof. They had to prove to you that at the time this bus left the possession of AeroCoach, it had a design defect. But they couldn't prove that to you today. So you're going to be told about the law, and the judge will explain that for a design defect to exist, they had to prove that the bus was unreasonably dangerous as designed. And there has to be a safer alternative they could have used instead. A safer alternative that would have reduced the likelihood of Courtney's injuries, and one that was economically feasible to implement. So first, the plaintiff tried to show you that this bus was unreasonably dangerous, but they couldn't do that. Instead, they tried to make you make assumptions and rely on emotion instead of relying on the facts. You heard from Mr. Murray, and he claimed the windows were too large, but he couldn't tell you how much smaller to make them or exactly how big was too big. The reason he couldn't tell you this is because he didn't even measure those windows. He just looked at photos, made this statement, and asked you to fill in the gaps of what they needed to prove. The fact of the matter is, the size of AeroCoach's windows complied with all standards and regulations. They did nothing wrong. Next, they told you that the glass would have been stronger if it were glazed. It wouldn't have been so dangerous. And they just wanted you to take Mr. Murray's word for it. See, remember, they had to prove that this glazing would have actually prevented Courtney's injuries. And they said, oh, well, the glass wouldn't have shattered. But folks, you heard, Mr. Murray ran no tests to try to recreate what happened during this accident, which had an extreme set of circumstances. The bus swerving, Gary Winters over the median, both going up to 80 miles per hour, and to top it all off, it's raining. Mr. Murray could not tell you that this glazed glass would have held up any better in the events of this accident. Dr. Zielinski told you glazing would not be any safer. He told you glazed windows still break, they can still cause harm. And he even told you that sometimes glazed windows can be more dangerous. That when you glaze those windows, it can cause the windows to pop out and passengers to be ejected. Folks, you heard that glazed windows was proposed as a rule, but it was never accepted. because it wasn't actually safer. See, they wanted to talk to you about this crash from the 80s today, but they have no evidence that the circumstances were actually similar. They have no information about the type of glazing used on that bus, the size of those windows, how they compare to the size of Aero coaches. They don't know the speeds of the bus. They don't know the speed of the other car involved. They didn't even say that the other crash involved another driver like Gary Winters plowing over a median, potentially high, and slamming into the bus. They don't know anything about the similarities other than both involved buses, and they both fell on their side. Again, glazed windows are not federally required. There's no Lone Star statute requiring glazing. They could not even show you that most other bus companies do it. The plaintiff keeps telling you Aero Coach should have gone above and beyond, that following the regulations wasn't enough. But folks, those regulations set the safety standards. That's why Aero Coach followed them. The plaintiff's case is about emotion, but your job here today isn't that easy, because you have to look at all of it. You have to consider whether this alternative was economically feasible. And the plaintiff's expert told you, well, NHTSA said it would be $87 to glaze these windows, but he didn't run any calculations of his own. He didn't tell you how NHTSA came to those numbers. He said there are many different types of glazing, but we didn't hear what type of glazing NHTSA was even considering when they gave that number. They gave you one set of numbers that they did not verify from a proposed rule that never got accepted. That is not proof. That is just asking you to make assumptions. Dr. Zielinski told you it is expensive to glaze windows, and because these types of accidents are rare, it did not make sense for Aero Coach to do that. Folks, we showed you that this bus was designed safely. The windows complied with all regulations. The seat belts complied with all regulations. The roof complied with all regulations. They complied with that compartmentalization too. Those seats were where they needed to be. The fact of the matter is the plaintiff has no evidence that this bus was unreasonably dangerous when it left Aero Coach. They're asking you to believe that Aero Coach had to design the safest bus potentially in history, but that is just not reasonable. The plaintiff failed to meet their burden. This bus was safe. Furthermore, they're ignoring Ms. White's own choices here. How her choices led to her injuries. She saw that the bus driver wasn't looking at the road, but she stayed standing. She saw as those cars got backed up, but she stayed standing. She felt as the bus driver swerved, but she stayed standing. She saw as Gary Winters came into view, faster and faster, closer and closer, but she stayed standing. Aero Coach could not make Courtney sit. They could not make her buckle up. Folks, we are here today because of what Gary Winters did. Without Mr. Winters, this accident would not have occurred. Miss White would be fine. We would not be sitting here. He drove over that median, going up to 80 miles per hour, and he slammed into the side of that bus. That was out of Aero Coach's control. There was nothing they could do to stop him. Before Gary Winters, those windows were fine. Before Gary Winters, Miss White was fine. Mr. Winters was out of control. Folks, when an accident like this occurs, it is natural to want to find someone to blame. We understand if you feel sympathy for Miss White, but you're not here today to judge out of sympathy. You're here to apply the law to the facts. Sympathy aside, you know that Aero Coach is not to blame for what happened to Miss White. Gary Winters is. It was his choices on July 4th that led to this accident, and there was nothing that Aero Coach could have done differently. This accident was out of Aero Coach's control, and we ask you to find them not liable. Thank you.
All right, Mr. Mance, do you have any, would you like your 3 minutes? In fact,
Yes.
I'll give you the extra 4 seconds if you want.
Oh, I appreciate that. That's very generous of you.
All right, you ready to proceed?
Yes, Your Honor.
All right, let's go.
If you're standing and you're showered with shards of glass, you're going to get cut. If you're sitting and you're showered with shards of glass, you're going to get cut. If you're buckled up and you're showered with shards of glass, you're going to get cut. What happened to Miss White isn't about her choices, it's about the defendants. Their windows were too big. They were too weak and they were too cheap. Their windows were defective. Find them liable. Thank you.
All right. Thank you, counsel, and congratulations to both teams. You both did a remarkably good job. So let's bring in, if we could, everyone. Now, John, do we need to sign off at this point?
Yes, Your Honor, I have just a couple things to say. So the round's now concluded. If everyone would please turn their cameras and audio off while the judges complete their ballots. But please stay on until all the ballots have actually been received. Then following that, we'll do brief comments. Judges, when you've received confirmation that your ballot is submitted, please turn your camera back on.
John, I submitted mine and I got back that it was accepted, but I did not see the and the scoring indicates my choice, but I did not see the line that is supposed to be there to pick which team. I had a score that indicates which team, but I didn't see the line.
Okay, so you just had a score that indicated.
Yes.
Okay.
Joe, if you actually scored it, you won't get
Hey,
that.
gentlemen.
Yeah.
Please do not discuss scores. Mute your microphones, mute your screens. If you have a question, contact me or Sarah. Your Honor, all ballots have been received and confirmed.
All right, is it just the judges that are in this room now, or are the contestants also?
The contestants are still in the room.
Yes, Your Honor. The contestants are still in the room. They just currently have their videos muted. Also, the judges, all y'all may introduce yourselves and provide some feedback to the advocates if the advocates want to turn their cameras on at this time. Judge Acker, I'll let you take the lead as to divvying up who goes
Just answer their.
All right.
Susan.
I'm not sure if we have 17 people that have or want to make
Susan's
comments.
on.
So let me just say one thing to start with. I thought all four of you did an excellent job. I thought you were great. I think it gives us great confidence for the future of the bar and the future of the trial bar to see students like you, soon to be lawyers like you, that will that have the kind of future I think we think you have. I'll introduce myself, and then I'm going to turn it over to Susan Phillips, who is the chair of our committee. She's sitting there in Louisville, and my name's Rodney Acker. I am a partner with Norton Rose Fulbright in Dallas. So Susan, do you want to run the comments from here and see who has comments?
I will. Thank you very much, Rodney. Let me just congratulate all of you all for an excellent job. I was very impressed. I think we all are very impressed with what we saw today, and really what we've seen this entire tournament has been great. But you all are the cream of the crop, and it was a privilege to watch you all and a privilege to judge you. I think it's very, very evenly matched, and it'll be very interesting to see who comes out on top. What I'd like to do right now is just to go through and have all of the judges introduce themselves and tell you where we're from. And I think you'll be very impressed that you're being judged by top trial attorneys all across the country. Again, my name is Susan Phillips. I practice in Louisville, Kentucky.
And John Phillips, also from Louisville, Kentucky. We are both in the firm of Phillips, Parker, Orbison, and Arnett, and do principally professional liability defense.
Forgot about that part. Okay. Monty, you're next on the screen. Do we want to just go around?
I'm Monty Clitheroe. I practice in Springfield, Missouri with the firm of Taylor, Stafford, Clitheroe, and Harris. Been in practice for 43 years and primarily do insurance defense and legal and congratulations to all. Did a good job because the two best teams got here.
Laura, I think you're next.
Well, there's two Lauras, so I'm not sure. I'm Laura Menninger. I am a criminal defense lawyer primarily. I'm in Denver, Colorado with the firm of Haddon, Morgan. Y'all were fantastic. I was super impressed by every one of you, and you should be very proud of the performance that you did today. And I really look forward to seeing you in courtrooms across the country.
Marty? Marty Jones?
I'm sorry.
You're muted.
I think we're all in different order, so I'll just call you all as we go around.
Yeah, thank you. Marty Jones, I'm a lawyer in Amarillo, Texas, and I practice trial law on all sides of the docket.
He is the drafter's problem.
You all should know that Marty is the author of the problem that the case that you just argued, and he frequently writes the problems for both the regional and the nationals and just does a beautiful job, as you can see.
Don't blame me for the problems.
We're not blaming you.
I was intoxicated.
I blame you. I blame you.
Okay, Mike Walsh.
Yeah, Mike Walsh. I practice in Hartford, Connecticut, and I'm a personal injury attorney, a plaintiff personal injury attorney. So I really enjoyed watching this problem, and you guys, you did great with it. You really did. I was so impressed. So congratulations, and I just hope I never run up against any of you guys in the courtroom. Good luck.
So true. Joe Crawford.
Hello, my name's Joe Crawford. I practice in Philadelphia, Pennsylvania. I've tried most types of civil cases, most recently focusing on commercial cases and representing lawyers. Really an honor to see you work. It's so inspiring. Thank you for all you've done and congratulations.
Thank you. Okay, Brittany.
Good afternoon. I'm Brittany Harrison. I'm the president of the Texas Young Lawyers Association, and I'm also a family law attorney at Goranson, Bain, Ostley in Dallas, Texas. And all four of you did a phenomenal job, and I would have any of y'all as my trial partner any day. So
You actually have a trial next week, as I recall.
I settled yesterday.
Oh, good for you. Oh, good, good. Okay, Richard Strasberg.
Yes, Richard Zielinski from the great state of Boston, Massachusetts. I'm here because I just can't make a living as a country and Western singer. And the only other thing I'll say is that if the defense doesn't win, my cousin Andy will not be invited to the Zielinski 4th of July outing this summer.
Exactly. Okay, Richard Strasberg.
So I'll just echo the performance was really tremendous for all four of you. I am practitioner of criminal law. I'm the chair of the white collar and investigations practice at Goodwin Proctor based in New York City.
Thank you. Okay, Scott.
Good afternoon. I'm Scott Green. I am with Brian Cave, Leighton Paisner in Atlanta, Georgia. I do solely civil work, but mainly on behalf of corporations, but on both sides of the V. And I'll just say 2 thumbs up, guys. You did a super job. Thank you.
Okay. All right, Judge Townsend.
So I'm Karen Townsend. I'm a retired district court judge from Missoula, Montana. I thought this was terrific. You, as I have told, I think most of you before, you're better than a lot of the lawyers I saw practice in my courtroom. I would be proud to see you at any time. Good luck to you. It's good that we can pass on the work of being a trial lawyer to such talented young people.
Thank you. Okay, Bill Ford.
Congratulations to you all. You were fabulous. I'm Bill Ford. I practice law in San Antonio with my own firm of Ford Murray, and I have a lot in common with Brittany as I'm listening to her. Both I practice family law and commercial litigation, and I was president of TYLA, the co-sponsor of this, long before Brittany was ever born, I'm sure. I was president of TYLA back in the mid-'80s. So congratulations to all you contestants. You were really talented today.
Thank you, Bill. I did not know that about you. Laura, Udall.
I'm Laura Udall. I practice criminal law. I'm out of Tucson, Arizona. I seem to be spending a lot of time in Oklahoma right now working on McGirt cases. All I have to say to you guys is the future looks very bright for us. Keep it up. You are all fantastic.
Thank you. Okay, Celeste.
My name is Celeste Higgins. I'm a white collar defense practitioner in Miami, Florida. I was, as I think I told a few of you, I was in your shoes because I was a participant in this competition, and it's something that I still remember to this day. I hope you will remember it always. I hope it helps you advance. I think you guys are well on your way. It was a fantastic final trial, and really just amazing on everyone's part. Thank you.
Last but not least, the infamous Gary Winters, back from the dead.
Yes, the real Gary Winters, and I do hold it against Marty for defaming me and my family. I am.
I don't feel lawyers to represent you.
I know, yeah. I practice in Cincinnati, Ohio, with the firm of McCaslin and McCaslin. My current practice is mostly employment litigation, although I've done a whole lot of things over the years, including products liability cases such as you've tried here. It was a spectacular job, and if any of you want a job in Cincinnati, give me a call.
Susan, I think we may have
Joe?
missed the other Joe.
I saw the other Joe, just now saw him pop up on my screen. Sorry, Joe.
Yeah, Joe Alexander with the Alexander firm in Houston. I practice with my son. I do 80% personal injury plaintiffs work and about 20% aviation defense work. And as I think I've told some of you in prior rounds, the four of you ought to call me on Monday, and we'll start a little 5-man firm here in Houston.
Rodney, I don't know if you, Rodney, of course, is, as he told you all, the president of the American College of Trial Lawyers. And Rodney, you want to tell them a little bit about your practice?
Yes, it's all civil, or 99.9% civil. Mostly on the defense side. I represent primarily banks, investment banks, in securities cases and commercial banking cases, real estate fraud cases, had some antitrust cases, including a couple of cases for NASCAR when they got sued for antitrust, for a couple of antitrust cases. But it's been mostly on the civil side and primarily on the defense side.
Thank you. And Rodney, we're all proud to say, was a member of this very committee for many years and chaired this committee. So we're all just so proud to have him as the president of the college. It makes us all.
Thank you.
It's wonderful. All right. Does anybody have anything else to say to the teams before we retire and discuss among ourselves some further business? Okay, then Mr. Bailiff, I'm not sure how we do this, but you need to move us into another room or move them out of this room or whatever needs to be done.
All right, hi, everybody. Oops, let me change that background. There we go. Sorry about that. Hi, everybody. All right, at this time, this is the end of the round. I'm going to go ahead and stop the recording. To our advocates,